All right, let's do this. We are diving deep into Philippine labor law. Specifically for you. You wanted to know more about this, and we've got you covered. We have a whole bunch of Supreme Court rulings, really recent ones, 2020 to 2022.
And these aren't just like abstract legal stuff. They're real stories, workplace dramas that went all the way to the highest court.
Exactly. We're not trying to make you a lawyer by the end of this. Think of it more like you're getting a peek behind the curtain, seeing how the law actually plays out in Filipino workplaces. And believe me, some of these cases, well, they might make you rethink a few things about your own job. Wherever you are in the world, this stuff is relevant. But before we jump into all that drama, could you give us a little context? Like, how does the Philippine legal system work? Why are these Supreme Court rulings such a big deal?
Well, the Philippines uses a civil law system, which means it's based on, written laws and codes. And at
Yeah.
the very top, you have the Supreme Court. Their decisions, they set the precedent. All the lower courts have to follow them.
So it's not just about solving one case at a time. These rulings actually shape the law for everyone.
Yeah, that's exactly it.
Got it. Okay, ready to dive into some real-life legal battles.
Let's see it.
Our first theme is, well, I think we've all heard of this, getting fired for misconduct. What does that actually mean in the Philippines?
That's the million-dollar question. The phrase gets thrown around, but honestly, figuring out what's actually a fireable offense, it's not always clear-cut.
Yeah, that's for sure. Our first case, Yemi v. Serrano v. FCT Finding Investigation Bureau. This one really shows what I mean. Serrano was a supervisor, government agency, overseeing some contracts, Philippine National Police, armored vehicles, big budgets, the whole shebang. And it turned out some things weren't quite right with those contracts.
Right. Some shady dealings going on.
Hmm.
And here's the kicker. Serrano, he got fired, but not for being directly involved in the shady stuff, for doing nothing about it. The court, they found him guilty of grave misconduct, which in the Philippines, legally, that's a big deal.
So wait, he's punished for what he didn't do. Doesn't that seem backwards?
It might feel that way. But the court, they had their reasons. To be grave misconduct, it's not enough to just be passive. It has to be like a blatant disregard for the law, for ethical standards, a deliberate choice to look the other way when you actually have a duty to act.
Makes you think. Have you ever seen something at work and it seemed off, maybe even a bit unethical, but you just didn't get involved? This case makes you wonder where the line is, right?
It definitely does. This ruling, it's a message about accountability, especially for people in charge, supervisors. You can't just say, oh, I didn't know, not when things go wrong on your watch.
So staying silent can get you fired.
Yeah.
But what about when you are doing things, making decisions, relying on your team, and things still blow up? That's where our next case comes in. GM Loretto P. Sears v. National Electrification Administration Board.
This case, Sears was a general manager, electric cooperative. He got in trouble because of, well, financial problems within his organization. Sounds familiar, right? But this time, the outcome, it was totally different.
Hold on. So there were money issues, but he wasn't held responsible. How did he pull that off?
Sears' defense was that he relied on reports, certifications, stuff his team gave him. And the court agreed. They said there wasn't enough proof to show that he should have been suspicious. Basically, he trusted his people, and they didn't find him personally liable for what happened.
Wow. Put yourselves in his shoes. You're the boss. Everything seems fine. And then bam, investigation, accusations. Your whole career is in question. It really makes you think about leadership, right? And how far your responsibility actually goes.
For sure. It shows how important checks and balances are in any organization. You need good communication, oversight. Leaders, they have to be informed, but they also need to be able to trust their team.
It's a tough balancing act. And while we're talking about messy situations, we should mention Joel A. Tapia VGA2 Pharmaceutical. This case reminds us that even when someone is doing something wrong, if the company doesn't handle it right, they can get in trouble too.
In Tapia's case, he had a big argument with his boss, got fired because of it, and the court, they agreed his behavior was bad enough to warrant that. But the way the company did it, all informal, verbal, that was a no-go.
So even if you're in the right legally, you got to follow the process. Documentation, formal procedures, it matters, even when things get emotional.
Absolutely. Said and done in the eyes of the law, those are two very different things. Employers, they have to be careful, even when they're dealing with difficult employees.
Okay, moving on from misconduct, let's tackle something that can be just as tricky. Employment status. You'd think it's simple, right? Either you're employed or you're not. But the lines, they get blurry.
This is a really important part of labor law because it determines, all sorts of rights and protections for workers. Are you a regular employee with all the benefits, project-based with a limited contract, or a freelancer on your own? Figuring that out, it's not always obvious, and that's when the disputes start.
Let's break this down with a case that might surprise you. Steelweld Construction v. Serafin H. Hachano. This one, it's a wake-up call for anyone who thinks that project employee label means a company can do whatever they want.
Yeah, that's right. Steelweld, they tried to argue that their workers were temporary, just there for specific projects, but the court saw through that, declared them regular employees all along.
What gave it away? What made the court decide these guys were more than just temporary hires?
Well, a couple of things. First, the workers, they didn't have contracts, specific ones outlining the terms of, their project work. And second, Steelweld, they hadn't filed those reports, the termination reports, with the Department of Labor and Employment after each project, which they're legally supposed to do. It seems small, but legally, it's a big deal.
It's like they didn't cross their T's and dot their I's, and it ended up biting them back. Shows how important it is to have everything in writing and to follow the rules every step of the way.
Exactly. And this case also shows how important abandonment is. Steelweld, they tried to say the workers had abandoned their jobs, but the court wasn't having it, especially because one worker, he'd been on sick leave.
So just being absent from work, even for a while, it doesn't automatically mean you've given up your job.
Right. There has to be a clear sign that you want to end the employment relationship. A company can't just assume you've quit, not without solid proof and proper communication.
Okay, ready for another employment status roller coaster? This next one, Rodrigo A. Upod v. Anon Trucking. It shows how easy it is to be totally wrong about what kind of employee you are, even after years at the same job.
This case, you had a truck driver, worked for the same company for 8 years, thought he was an independent contractor, freelancer. Paid per trip, no benefits, no formal contract. Pretty common, right? Gig economy stuff.
Sounds pretty straightforward. What's the problem?
Well, suddenly, the company just stopped giving him work. When he complained, the court dropped a bombshell. He was an employee all along, and they'd illegally dismissed him.
8 years. And they just
Yeah.
cut him off like that. That's harsh.
It is, and the reason it matters is control. The court, they figured out that even though there was no contract, the company, they controlled everything, his routes, his deliveries, basically his whole work life. And because they had that control, legally, he was an employee, no matter what they called him.
Wow, anyone out there doing gig work? This one's for you. Just because you get paid per job or you don't have a traditional contract, it doesn't mean you have no rights.
That's exactly it. This case proves that what actually matters is the reality of your work, not what's written on paper or not written. There's this fourfold test they use. It looks at who hires you, how you're paid, what your work involves, and who can fire you. That's what truly determines if you're an employee or not.
Okay, so we've learned that doing nothing can be misconduct, and how even long-term gigs can be misclassified. Looks like Philippine labor law is full of surprises. What else is coming up?
Welcome back to our deep dive into Philippine labor law. Still fascinating, sometimes still a bit confusing.
I'm starting to understand why people make movies about this stuff. It's all about, power struggles.
Yeah.
Who's in control? Who comes out on top? But these aren't just stories. These are people's actual lives we're talking about.
Exactly, and the stakes, they can be incredibly high, especially when you're talking about money, about financial benefits. Our next case, Philippine National Construction Corporation v. NLRCs, it throws a wrench into how we think about employee benefits, specifically within government-owned companies.
So we've got PNCC, a government construction company. They had been giving their employees this nice mid-year bonus for years. Everybody's happy, right?
Well, happy until the company, they went through some changes, restructuring, and they decided no more bonus. The employees, of course, they weren't too thrilled. They said the company was violating this principle, non-diminution of benefits.
Yeah, that makes sense. Sounds like a classic bait and switch. You get used to this perk, then poof, it's gone. What happened? Did the court side with the employees?
They actually didn't, and this is where it gets interesting. The court, they get it. Protecting employee benefits, that's important. But they said PNCC, being government-owned, well, different rules apply. There were new laws. The president had to specifically authorize these kinds of bonuses.
So even though they'd been doing it forever, the law changed. And they couldn't just keep handing out bonuses without, jumping through a bunch of hoops. I bet a lot of companies don't even realize these things exist.
It definitely shows that Companies, especially ones in those highly regulated industries, they have to keep up with the law. Something that was okay yesterday might be a violation today. It's tricky.
Okay, let's move on to something that's always a bit controversial. Labor contracting. Ronald O. Martinez v. Magnolia Poultry Processing Plant. This case gets into, who's really the boss in the workplace.
Yeah, this one involves workers. They were hired through a contractor, Romac, to work at a poultry processing plant, doing all sorts of jobs, sanitation, production line stuff, essential work.
Typical outsourcing situation. What's the issue here?
The issue is the plant, they decided to stop using Romac, left the workers hanging. They argued that Romac, this was a labor-only contractor, which is illegal in the Philippines,
Yeah.
and that Magnolia, the plant, they were the real employer all along.
So they were trying to bypass the contractor and hold the actual plant accountable? Did it work?
In this case, it didn't. The court said Romac, they were a legitimate contractor, meaning they had their own capital, resources, they had actual control over their employees. It wasn't just a shell company.
So it's a reminder that not all labor contracting is bad. There are good reasons for companies to outsource sometimes, and the law acknowledges that.
It's true. But this case also shows how important it is for both sides to know what they're getting into. Workers, they need to know who they really work for, what their rights are. And companies, they need to make sure their contractors are doing things legally, ethically.
Right. Speaking of tricky situations, let's look at reliable industrial VCAL. This one sheds some light on this practice, floating status. You see it a lot in the security industry. It involved these two security guards. They raised concerns about their pay, and then things got weird.
So transferring employees, usually that's within a company's rights. But here, the guards, they said these transfers were retaliation. They got moved to places super far from home, made it almost impossible to keep working.
Sounds like the company was making their lives difficult on purpose, hoping they just quit. Is that even legal?
It's a gray area, but in this case, the court sided with the guards, called it constructive dismissal. The timing, it was too suspicious, moving them right after they complained. And making them commute so far, it looked like they were being forced out.
So even something routine, like transferring someone, if it seems unfair or like revenge, the company better have a good explanation, especially if the employee has already complained about something.
Transparency is key, for sure. And speaking of knowing your rights, the next case, Rodrigo A. Upad v. On Trucking, it shows how crucial it is to understand what kind of employee you are. Remember that truck driver? Thought he was a freelancer for 8 years.
Oh yeah, that was wild. The company just stopped giving him work, and he was totally blindsided.
Classic case of misclassification. The driver, no formal contract, paid per trip, thought he was his own boss. But the court, they looked at the reality. The company, they had all the control. So legally, he was an employee. Didn't matter what they called him.
Anyone listening, if you're in the gig economy, pay attention. Flexible hours, working on projects, it doesn't automatically mean you're a contractor. If the company controls what you do, when you do it, how you do it, you're probably an employee under the law.
And being an employee means you get certain benefits, protections, minimum wage, overtime pay. You can't just be fired without a good reason. Know your rights.
Exactly. Don't let anyone tell you otherwise. Speaking of power dynamics, our next case, Bernilo M. Aguilera v. Coca-Cola FEMSA Philippines. It deals with that dreaded word redundancy. Shows that even if you're high up in the company, making good money, you're not safe from corporate shakeups.
Aguilera, he was climbing the ladder at Coca-Cola, seemed like he had it made. Then management changes. His whole position gets declared redundant.
Redundancy. The corporate way of saying, we don't need you anymore. But it's not always that simple, is it?
Nope, not always. Legally, redundancy means your job, it's just not needed anymore. Changes in how the company operates, technology, whatever. But here, the court, they smelled something fishy. They thought maybe the company was using redundancy as a cover-up.
What do you mean? What were they hiding?
Well, they basically took Aguilera's job, split it into 2 new positions, but with lower salaries. Looks like a way to cut costs and get rid of someone they didn't want.
So they replaced him with 2 cheaper employees. Harsh.
The court thought so, too. They ruled for Aguilera. Said the company, they didn't do redundancy properly, didn't use fair criteria to decide which jobs to cut. It was a win for employees. Shows that companies can't just use redundancy as an excuse to fire people unfairly.
It's good to know the courts are paying attention, calling out companies when they're trying to pull a fast one.
Yeah, redundancy, it's a real thing. Companies do need to restructure sometimes. But it has to be done legitimately, honestly, not as a loophole to mistreat people.
Okay, let's revisit a concept we talked about earlier, abandonment. the case Steel Weld Construction v. Serafin H. Cano. It shows how this defense can backfire on a company if they're not careful.
Remember those workers, the ones Steelweld said were just project employees? Well, the company also tried to claim those guys had abandoned their jobs.
But we already know the court said they were regular employees all along. How can you abandon a job you're legally entitled to?
Exactly. The court wasn't buying it. They said, again, just because someone's absent from work, even for a while, it doesn't automatically mean they've quit. There has to be a clear intention to end the employment relationship. And Steelweld, they had nothing to prove that.
Good lesson for everyone, both sides. Companies, you need to talk to your employees when they're absent. Figure out why. Document everything.
And employees, if you need time off, keep your employer in the loop. Let them know what's going on. Give them proof if you need to. Don't just disappear and hope for the best.
Right, communication is key. Okay, ready for another constructive dismissal case. Reliable Industrial v. Cal. This one shows how seemingly small things a company does can create a really hostile environment, basically forcing an employee to quit.
Remember those security guards? The ones who got transferred to those faraway locations after they complained about their pay. The court, they said, yeah, companies can transfer people, that's normal, but you can't use it as punishment or to get back at someone.
So they said the company was making their lives so hard, it was like they were being fired, even though they technically weren't.
That's it. That's constructive dismissal. It's not always a big dramatic firing. It can be about making the workplace so bad, the employee has no choice but to leave.
It's sneaky, but it's still a form of abuse, and I'm glad the courts are recognizing it.
It is. Employees have rights, and the law protects them from this kind of stuff.
Okay, let's talk about a case that might resonate with anyone who's ever felt stuck in a dead-end job. Rodel F. Bantagon v. PVC Master Manufacturing Corporation. This one shows how corporate restructuring can be used to cover up shady stuff.
So we've got Bentagon. He worked for this company, Boatwin. Got promoted. Things were going well. Then Boatwin, they changed their name, become PVC Master Manufacturing Corporation. Seems like no big deal, right?
Yeah, just a name change. Who cares? But I have a feeling there's more to it. What happened to Bantagon?
Well, shortly after the name change, he's out of a job. Says he was constructively dismissed. The company was retaliating because his brother had sued them. PVC Master, they said, nope, we're a totally new company. Nothing to do with Boatwin. We don't owe this guy anything.
So they were trying to pull a switcheroo. Same people, same business, different name. Trying to get out of their obligations. Did they get away with it?
No way. The court saw right through them. They said PVC Master was basically just Boatwin with a new name. The whole name change thing was just to avoid responsibility for Bantagon's rights as an employee. Sneaky.
Companies can't just reinvent themselves and erase the past. The law remembers, and the courts will look beyond the surface to protect workers.
This case highlights how important it is to pay attention, especially for employees. If your company is going through changes, merging, being bought, whatever, look closely at what's happening. Make sure your rights are protected. Don't be afraid to get legal help if you need it.
All right, let's wrap up this part of our deep dive with a case that's, well, it's a bit lighter, but still important. Moreno Dumapas v. Lepanto Consolidated Mining Company. It shows that even when you win in court, the fight might not be over.
This one's about calculating back pay and benefits. A bunch of workers, they were illegally dismissed. Supreme Court said the company had to pay them. But then the argument became, how much?
So even when you win, you still got to fight for every penny.
Sadly, yes. The workers, they said the calculation should include raises, benefits, stuff they would have gotten if they hadn't been unfairly fired.
Correct.
The company, well, they wanted to pay as little as possible.
Classic move. Delay, deny, hope they give up. What happened? Did the workers get what they deserved?
In the end, yes. The court said the calculation had to include all those guaranteed raises, all those benefits, things they were entitled to under their contracts, company policies. It was a win for paying attention to the details.
Sometimes it's not enough just to win. You got to make sure justice is done, down to the last peso.
It shows that the courts are willing to go deep. Look at all the little things in these disputes to make sure workers are compensated fairly.
So anyone out there, if you're ever in a situation where you're owed back pay, benefits, don't just take the company's first offer. Know what you're entitled to. Don't be afraid to push back.
That's good advice. It's your money. You earned it. You have the right to fight for it.
And on that note, we'll take a short break. Back in a bit with even more fascinating cases from the world of Philippine labor law. Back again. Ready for the last leg of our Philippine labor law marathon. We've seen some pretty wild stuff already, but I have a feeling you've got even more fascinating cases for us.
Oh, yeah, definitely. These cases, they really show just how diverse and complicated Philippine labor law can be. Everything from retirement benefits to, working for religious organizations, even what happens when a company changes its name, it all gets tangled up in the law.
All right, color me intrigued. Hit me with your best shot. What's the first case on the list?
Well, let's start with retirement benefits. This case, Leonardo Jamago Salabe v. Social Security System, it really highlights how important it is to understand Social Security laws, especially for people working in, like, informal jobs.
Retirement benefits and formal employment. Sounds like a recipe for disaster. What happened?
So Leonarda, she worked as a helper at a small eatery just for about a year. Her employer, Anamacas, she registered Leonardo with the Social Security System, the SSS. That's where you get pensions, all those benefits. Even after Leonarda stopped working at the eatery, she kept paying into the SSS voluntarily for years. When she reached retirement age, she started getting her pension. Everything seems fine, right?
Yeah, sounds like she did everything right. What's the problem?
Years later, the SSS, they decided to stop her pension. They said there was no real employer-employee relationship between Leonarda and Anamacas. So her SSS membership, they claimed, it wasn't even valid. Can you imagine? After all that time paying in, suddenly they say you're not entitled to anything.
That's terrifying. Talk about a broken system. So what happened? Did the court fix this?
The Supreme Court, they ruled in Leonarda's favor. They said, yeah, proving employment relationships can be tricky, especially in places like small eateries where things aren't so formal. But they pointed out that Anamacas, by registering Leonardo with the SSS in the first place, that showed she did consider her an employee.
Actions speak louder than words, right? You can't just go back and say, nope, she never worked for me, after you already treated her like an employee.
Exactly. The court also said that Leonardo had a right to those benefits. After all those years of contributions, it was a victory for common sense, really, for workers who depend on the Social Security systems, especially in retirement.
That's good to hear. The system actually worked for once. Okay, what else have you got?
Let's move on to something anyone who's worked a short-term contract or project can relate to. Salvador Awa Innocentis VR Sijuco construction. This one gets into that whole debate about project-based employment versus regular employment.
Ah, that classic question. Are you a real employee or just a temp? I bet this causes a lot of arguments.
You said it. In this case, some workers, they'd been employed for years on different construction projects, renovations. They said, hey, we're basically regular employees. We deserve benefits and protections. The company, of course, said, nope, you're just project-based workers.
Same old story. What you're called versus what you actually do. So what did the court decide?
The court didn't buy the company's argument. They looked at the work itself, how long these people had been employed, the company's hiring practices, gamut. They ruled that the workers were, in fact, regular employees.
Even though they were hired for specific projects, the court saw through the company's tricks. What was the key factor here?
Well, the company messed up. They never told the workers about this whole project-based status when they were hired, and they hadn't filed those termination reports with the DOE after each project, which they're legally required to do. You got to follow the rules, right?
Paperwork matters. You can't just call someone a project employee and think that's the end of it.
That's the lesson. The law looks at what's actually happening at work, not just what's written down. If you keep hiring the same people over and over for similar jobs, they're probably regular employees no matter what their contract says.
Okay, so the court is looking out for workers even in informal settings, even on project-based gigs. What's next?
This one, Ariel Espina v. Highlands Camp, it's about nonprofit organizations. Shows that even when you're doing good work, you still have to follow labor laws.
Yeah, people think nonprofits are different, like they get a free pass.
Yeah.
But that's not how it works, is it?
Nope, not at all. This case, a group of workers, they had been employed by this religious organization for over 10 years, cooking, cleaning, maintenance, all kinds of tasks. They were hired again year after year, thought they were regular employees, deserved benefits, job security, all that.
Sounds pretty stable. What happened?
In 2011, the organization just didn't rehire them, brought in new people instead. The original workers, they felt like they'd been kicked to the curb unfairly. Filed a complaint.
A decade of work, and then, poof, they're out. That's cold.
The court agreed. They said your employment status depends on what the employer does, what kind of work you're doing, not just what they call you or what their intentions are. Those workers, they were basically doing essential jobs year after year. Legally, that made them regular employees.
So it doesn't matter if you're a charity, a nonprofit, whatever. Employment relationships, they're governed by the law. Workers have rights, and employers have to respect them.
Exactly. And it's not just about labels or good intentions. It's about what's actually happening in the workplace. All right, ready for another case? This one's relevant to anyone who's ever been accused of screwing up at work.
Oh, I think we've all been there at some point. Lay it on me.
This case, Intercontinental Broadcasting Corporation v. Angelino B. Guerrero, it's about negligence. When an employee gets fired for messing up, but the whole situation just feels unfair, like the company didn't handle it right.
Negligence, that's a serious accusation no matter what job you do. What happened here?
Guerrero, he was a technician for this broadcasting company, IBC-13. Worked there for over 20 years, good track record, no problems. Then, out of the blue, they asked him to do this task. Logo superimposition. Not something he usually did. He made some mistakes, and the company, they used that as an excuse to fire him.
So, new task, no training, makes a few errors, boom, he's out. After 20 years. That's harsh.
The court thought so, too. They said the dismissal was wrong. IBC-13 didn't have enough proof that he was actually negligent. They pointed out he wasn't trained for this new task, and they let him keep doing it for months, no complaints. It was like they wanted him to mess up.
Wow, the court really called him out. It shows how important due process is. Companies, they have a responsibility to train their employees, especially for new tasks. You can't just throw someone in the deep end and then punish them for not knowing how to swim.
Exactly. Employers have to provide support, guidance, especially when they're asking people to do something new.
Okay, so we've covered retirement benefits, project employment, due process. What else is there?
Let's talk about floating status. This one's common in the security industry, but it can be a legal minefield. Alan Emdor v. Jamila. This case shows the limits of floating status and what happens when companies abuse it.
Floating status, that sounds like a fancy way of saying, we don't have anything for you to do, but we're not firing you yet.
You got it. In this case, a security guard, they put him on floating status. Basically just waiting around, no assignment, no idea what's going on. Happens a lot in the security industry, but the law says there's a limit. You can't just leave someone hanging forever.
There's a time limit on professional limbo. How long can they do that?
6 months, that's the max. After that, the employee, they can argue they've been constructively dismissed, and that's what happened here.
So even though he wasn't officially fired, they basically ignored him for so long it was the same as firing him.
Yep. And/or he was on floating status for over a year, kept asking for a new assignment, but nothing. The court said this was wrong, violated his rights. It was constructive dismissal, plain and simple.
Even temporary work arrangements, they have to be fair, they have to follow the law. Companies can't just keep people dangling forever. What's next?
All right, this one's a bit more serious. Anthony M. Mignano v. Stowe Thomas General Hospital. A nurse, accused of all sorts of things, gets dismissed. But the way the hospital went about it, it just wasn't right.
Hospitals, they're high-stress places.
Yeah.
No room for mistakes. But even then, they still have to follow the rules, right? Due process, all that.
Absolutely. In this case, the nurse, Mignano, he was left out of meetings, taken off the schedule, basically treated like he didn't exist. No one told him why.
Sounds like they were trying to make him quit without actually firing him. Did he just give up?
Nope. He fought back, filed a complaint, said it was a legal dismissal, that the hospital was making his life so miserable, he had no choice but to leave.
Another constructive dismissal situation.
You got it. The court agreed with Mignano, said the hospital didn't follow due process at all. They didn't tell him what he supposedly did wrong, didn't give him a chance to defend himself, basically made the workplace so toxic he had to resign.
So even when there are problems with an employee, companies can't just play games. They have to be clear, they have to follow procedures, give the employee a fair chance to respond.
All right, ready for a case that goes international. Domingo P. Gimele VCA. This one's about working overseas and those contracts people sign. It's tricky stuff.
International contracts, yeah, that adds a whole other layer of complexity.
Gimele was a mechanical technician, got sent to Ghana for a project. They accused him of safety violations, fired him. He fought back, said they didn't do it properly.
So even though he was working in another country, he could still take them to court.
He could, and he did. The court, they said, listen, even if you're working overseas, Philippine labor laws still apply. You got to follow due process. You need proof. If you're accusing someone of misconduct, the employee's rights are still protected.
Philippine labor law, it's got a long reach. Companies can't just ignore the rules because their workers are far away. Okay, what else?
Back to the Philippines for this one, but a very specific setting. The court system itself. Judge Winnie D. Espinosa v. Rodolfo Richard P. Balasnomos. This case shows how important hierarchy is, who's in charge, especially in legal institutions.
Judges and their clerks, huh?
Hmm.
I bet that gets interesting. What happened?
A judge, she filed a complaint against her clerk of court. He refused to issue a writ, even though she told him to. The clerk said he was just following the rules, but the court, they found him guilty of insubordination. Basically, he disobeyed a direct order.
Whoa, he went up against a judge. That takes guts.
It does, but it didn't end well for him. The court, they made it clear. Clerks of court, they have to follow the judge's orders, even if they don't agree. That's how the system works. Hierarchy, chain of command, you can't just ignore that, even if you think you're right.
Even in a system all about the law, you still have power dynamics. And sometimes that leads to conflict. Okay, we're almost there. 2 more cases to go.
All right. JS Unitrade Merchandise v. Ruperto S. Sampson. This one takes us back to constructive dismissal and abandonment. Shows how important it is to understand what someone's intentions are, what they're really trying to do.
Okay, hit me with another did he quit or was he fired scenario. What's the story?
Sampson, he was a sales manager. They offered him a demotion or a buyout. Basically, his performance wasn't good enough. He felt like they were pushing him out, so he stopped coming to work, filed a complaint for constructive dismissal.
Classic case of making someone's life miserable so they'll quit on their own.
Exactly. The company, they tried to say, nope, he abandoned his job.
But wouldn't his complaint, the one about constructive dismissal, wouldn't that prove he didn't want to quit?
The court thought so too. They said him filing that complaint right away, it showed he wasn't just walking away, he was fighting back.
Context matters. Just because you stop showing up for work, it doesn't automatically mean you've abandoned your job. There has to be that intention, that clear decision to leave.
And for our final case, ComCenter Phils, Inc. v. Camille B. Rossio. We're looking at the power of labor courts, what they can and can't do, their jurisdiction.
Jurisdiction, that's where things get really technical, right? What's this one about?
This case, it confirms that labor courts, they can handle cases about damages that happen because of the employer-employee relationship. Even if it involves stuff like extortion, unjust vexation, things that aren't your typical labor issues.
So even if it goes beyond the usual workplace stuff, the labor courts can still step in.
That's right. It's important because it means workers have a way to get justice for any harm that comes from their job, no matter what form that harm takes.
It's like a one-stop shop for resolving workplace problems. Makes it easier for the workers, and it shows that the labor courts are there to protect them.
Exactly. It shows how much power they have to handle all sorts of disputes, make sure things are fair for everyone involved, both employers and employees.
Wow, we covered a lot today.
Yeah.
Retirement benefits, international contracts, constructive dismissal, due process, you name it. Philippine labor law is a wild ride.
And these cases, they're just a glimpse, of what's really happening out there. The battles workers and employers are fighting every day.
I learned a lot. I think the biggest takeaway for me and for anyone listening is that knowledge is power. You got to know your rights. Employee or employer, it doesn't matter.
Yeah.
The more you know, the better you can navigate this whole crazy world of work.
I couldn't agree more. And the world of work, it's changing so fast, right? New technology, new types of jobs. It's more important than ever to stay informed, to fight for fairness, for justice, for everyone.
Thanks for joining us on this deep dive into Philippine labor law. We'll be back with more deep dives soon, exploring topics that matter to you. Until then, keep asking questions, keep learning, and keep fighting for what's right.